In many Indian communities, marriage functions as a merger of two families, an alliance negotiated by parents, where individual consent is often treated as secondary. However, the Indian Constitution classifies this choice differently. Under Article 21, which guarantees the right to life and personal liberty, selecting a life partner is an essential fundamental right. The Supreme Court reinforced this boundary in cases like Lata Singh and Shakti Vahini, ruling that communal or familial honor does not justify harassment and that individuals are free to marry of their own volition. The Shafin Jahan ruling extended this protection further, declaring that for consenting adults, no individual, parent, or institution possesses the legal authority to interfere with their marital choice. Despite these constitutional protections, manipulation and physical coercion remain common. When a marriage is built on force or deceit, the law provides specific, time-sensitive mechanisms to dismantle the contract. Criminal law serves as the first line of defense. If a person is physically confined to force a wedding, the justice system provides immediate relief before family law ever enters the picture. Section 87 of the Bharatiya Nyaya Sanhita, or BNS, criminalizes kidnapping or abducting a person specifically to compel them into marriage. Beyond physical abduction, Sections 69 and 81 penalize deceitful cohabitation and sexual intercourse obtained through a false promise of marriage. While these criminal charges address the immediate physical threat, the civil marriage contract itself remains. To erase the legal record, a victim must navigate the distinctions within the Hindu Marriage Act. The Hindu Marriage Act of 1955 categorizes flawed marriages into two distinct legal pathways: void and voidable. Under Section 11, a void marriage is dead on arrival. It holds no legal validity from its inception, creates no marital obligations, and requires no court decree to be considered non-existent. Marriages are void if they involve bigamy, where one party has a living spouse, or if the parties fall within prohibited degrees of sapinda relationship, meaning they are closely related by blood. A voidable marriage under Section 12 is different. It is a valid, legally binding contract that persists until one party formally petitions the court to annul it. The court can grant an annulment on 4 specific grounds: if consent was obtained by force or fraud, if a spouse is incurably impotent, or if there was an undisclosed pre-marriage pregnancy by another person. This distinction is critical. A void marriage never existed legally, while a voidable marriage remains a binding reality until a judge issues a nullity decree. A decree of nullity is the specific judicial order that erases a voidable marriage from the record, legally treating it as if it never took place. Obtaining this decree requires meeting a strict 1-year statutory limit. If consent was obtained by force or fraud, the victim has exactly 365 days to file for an annulment. This countdown begins the moment the physical force ceases or the fraud is discovered. Cautionary tone. Continuing to live as husband and wife after the discovery of fraud or the cessation of force carries a severe legal consequence. It forfeits the right to an annulment entirely, making the marriage contract permanent. However, Section 16 provides a humanitarian protection for families. Even if a marriage is annulled or declared void, any children born of that union remain legally legitimate. The Constitution guarantees the freedom to choose a life partner, but when that choice is stolen, the law only offers a narrow window for recovery. Restoring that autonomy requires decisive legal action before the clock runs out.